of the events because of the the use of alcohol and so forth that was involved.
We are passing forward a plea agreement. And subject to the court's approval, Mr. Himes would be entering a no contest plea to the amended charge of aggravated assault. That is a C felony. He will be sentenced to 6 years suspended. A condition of his probation shall be that he complete a psychosexual evaluation, follow the recommendations thereof, that he complete mandatory monthly drug screens, and there will be zero tolerance for any failed drug screens. He is to have no contact with Ms. Ashley Searcy, and this would run concurrent with Lewis County. Sorry, I didn't have that written on my copy. He does have credits from 7/1/25 to the present.
All right, Mr. Himes, raise your right hand. Let's place you under oath. State your full name for the record.
Keenan Travis Himes.
Mr. Himes, you're here today charged with, I think it's actually a charge of rape, and based on the...
Right out of the gate, this is a plea deal situation, meaning no trial unless the judge rejects it. And here's where it gets interesting. The original charge is about to be reduced. That raises a big question. Why would prosecutors agree to lower such a serious charge? Lack of evidence, risk of losing a trial, or something else? Stick around because the details matter.
Agreement is being amended to aggravated assault, and you're being sentenced to 6 years that will be in the Department of Corrections suspended. But have you seen or been shown a copy of the charges and talked them over with Mr. Howard? You and he discussed the range of punishments you're facing as well as any possible defenses you might have.
Yes, sir.
Well, it's indicated you want to enter a plea of nolo contendere or no contest. That simply means you understand what the state's evidence is. You're not going to admit you did anything wrong, but you're not going to contest the state's evidence when they tell me what their evidence is, and their evidence will be what I use to find you guilty. Do you understand?
Yes, sir.
You understand that you have the right, however, to plead not guilty and to have a speedy and public trial by jury?
Yes, sir.
Do you understand if you went to trial, you would have the right to have a lawyer and have one appointed, as we've done with the public defender?
Yes, sir.
You understand that if you went to trial, you'd be presumed to be innocent until such time, if ever, the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes, sir.
You understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by the use of a subpoena.
Yes, sir.
Do you understand that at trial you'd be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
You understand that if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
This is one of the most critical moments in any courtroom, the waiver of rights. The judge is making absolutely sure the defendant understands. By taking this deal, he's given up a trial, the chance to challenge evidence, and even the right to appeal. And notice how methodical this is. Every yes, sir locks it in further.
Yes, sir.
You understand that by entering this plea, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer has worked out.
Yes, sir.
You understand, however, that it's going to result in a conviction, a felony conviction that will be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime.
Yes, sir.
You understand everything I've explained to you?
Yes, sir.
Do you want to plead no contest according to this agreement and waive your right to a trial?
I do.
Is your decision to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No.
You understand I cannot accept your pleas unless I'm satisfied there is a factual basis for it and that you are in fact guilty. In other words, I have to know that you're guilty before I can accept this. You understand that?
Yes, sir.
And I want you to listen as the state tells me what their evidence would be if your case went to trial. General?
If this case would proceed to trial, the proof would show that on or about February 24, 2025, Miss Ashley Searcy and her husband, Nicholas Searcy, hosted a small get-together with Marlena Bell and Keenan Himes. During this get-together, Ashley, Nicholas, and Marlena became extremely intoxicated. Keenan was also drinking, but it is unclear how intoxicated he was. Nicholas ended up passing out on the couch, and Marlena had been throwing up, so she went to the hall bathroom to take a shower and sober up. While Marlena was in the shower, Ashley also got sick and puked on the floor and was laying in it. When this happened, Keenan assisted Ashley to the master bath, got her naked, and placed her in the shower. Ashley said that she doesn't remember any of this, but when she woke up, Keenan was in the bathroom and that he had, with Keenan over top of her, digitally penetrating her vagina. Ashley told Keenan to stop, and he grabbed her by the legs and pulled her bottom half out of the shower, and then performed oral sex on her for an unknown amount of time before Ashley heard Marlena knocking on the door, yelling for Keenan. At that point, he stopped and opened the door. The victim continued to tell Keenan to stop, and he proceeded on. Judge, I have Miss Cersei here in the courtroom. She would like to have an opportunity to speak to the court and the defendant. I've went over the proof with the victim ad nauseum. We've talked about potential outcomes at trial. I suggested this potential settlement. Which the victim has the blessing of the victim in this case. Some important things to note about the sentence: it is a mandatory in-person reporting, and aggravated assault, even though it's not checked on the plea form, aggravated assault is a 100% crime. That means if the defendant violates his probation and he's sentenced to serve, he's to serve 100% of those 6 years.
All right. Mr. Himes, do you understand that's what the state's evidence would be if this case went to trial?
Yes, sir.
You still wish to plead no contest to this charge?
I do.
Are you satisfied with your attorney's services?
I am.
You feel like Mr. Howard has done a good job of representing you competently?
I do.
Mr. Howard, do you know of any reason he should not enter the plea?
No, sir.
And I'm going to ask you and him to have a seat and allow me to hear from the victim in the case.